indicates a finding that the incident constituted a domestic battery. The Department of Agriculture asked an administrative law judge and now this court to look at the underlying facts from a 2014 criminal case and to impose a criminal consequence that was not imposed by the court. Federal law at issue specifically requires that the couple have cohabitated in a relationship similar to that of a husband or wife. No facts from the trial court's record indicate such a relationship. Such a relationship, if offered and proven at the time of the charges, would have required the trial court to impose a minimum mandatory sentence that it did not impose in this case.
Well, didn't it actually impose that sentence when it withheld adjudication and then took it away when it adjudicated him guilty and gave him 60 days county jail?
Correct, Your Honor, and that's why I think that the transcripts are very important to this case from that trial court hearing. At the first hearing, and there's some interesting parallels with some recent Supreme Court cases in this case. Both cases, or both resolutions by J.C. occurred at first appearance court. In the first case, there was no attorney heard from. There was a public defender present in the courtroom, but he did not participate in any way in the proceedings. Mr. J.C. pled no contest, received a withhold of adjudication, received a batterer's intervention, and 1 year probation is required as a minimum mandatory. However, when he came in, when he was rearrested a few weeks later, he came in, he was represented by counsel. Counsel, in consultation with the state of Florida, made an agreement, came to an agreement that this was presumptively not a domestic case because—
Where is that on the record that there was this agreement?
Well, it was an agreed-to plea, Your Honor, and the state does not have the authority to agree to a plea in a domestic battery case to waive the minimum mandatory.
Let me ask you about that, because you may not know, but I was a county judge and I did a whole lot of these domestic battery cases. And once somebody's adjudicated guilty and you've revoked probation, my understanding as a county judge was I didn't have jurisdiction to require them to do anything. So are you saying that the judge needed to revoke probation but still require your client to do this batterer's intervention program?
Your Honor, the statute actually required the judge in a domestic case to leave probation in place for a year. Even if he spent a year in the Duval County Jail, the judge was required, if it's a domestic case, to leave probation in place and require completion of the batterer's intervention course.
So you're stating that the later arrest resulted in sort of a new plea. So
the later arrest,
rather than the probation being violated, he just entered a new plea to battery?
No, Your Honor. The second arrest, the charges from that arrest were dropped. Correct. They were null prost. Right. What the new plea was to the violation of the probation and an adjudication of guilt on the original charge. However, the statute specifically contemplates, and this is a very unusual statute, the domestic violence statute contemplates that the judge shall put the person on probation for a year, but does not preclude the judge from imposing any jail sentence at all. So this is one case where even if a jail sentence is imposed, the person still must be on probation for the completion of that batterer's intervention course.
So your client actually got the benefit of not having to do the remainder of a year's probation? Is that what you're
It appears that's what happened, Your Honor.
Is he going to go back and turn himself in and do a year?
No, Your Honor, because it wasn't a domestic case.
What about the domestic violence surcharge, the 201 that's on the judgment?
Your Honor, I believe that the court should have actually refunded that or should have removed that when it determined it was not a domestic battery case. But the judge, I don't believe it is proper for the administrative law judge or the Department of Agriculture to be able to go back and impose a subjective analysis on a conviction 8 years after the fact to determine whether or not it was domestic in nature. And that's an important factor here. We're not dealing with a case where one of the objective criteria of 922G are present, such as marriage, sharing a child in common, I forget what some of the other objective criteria that are more expansive under Florida law, such as being siblings. Those are all objective criteria. We're dealing with something that's very subjective here, whether or not they lived in a common residence as if in a spousal relationship. We would argue that if we do have to go back and look at what the ALJ did, that there was insufficient evidence to prove that these two ever cohabitated. They always at all times maintained separate residences. The driver's license were at all times separate locations. He never moved his driver's license to California or away from his house in Duval County. She never resided at his house in Duval County. There was no testimony that she ever resided in his home in Duval County.
Can I ask you, there's not a crime in Florida of domestic violence battery, right? There's battery, and then if it's domestic violence, you have to do certain conditions?
That is correct under Florida law, Your Honor.
So how then is someone determined to have committed a disqualifying domestic violence battery?
Well, so both for purposes of Florida law and federal law, there are certain objective determiners that the courts have historically, and I'm not conceding the constitutionality of those, by the way, but there are certain objective criteria that the courts have gone back and looked at. Were the persons cohabitating? Were they actually married? Did the couple share a child in common? These are criteria that can be looked at, and there's objective record of these activities, whether it's a birth certificate, whether it's a marriage license, or on a more
how
subjective.
about some long-term, no dispute that a couple is long-term cohabitating. They've lived together for 10 years, the bills are shared, everything like that. How would that be proven to be domestic violence battery?
Well, so Your Honor, I think that's why the trial judge's findings or determinations are important, number one here. But the way those would be proven, possibly in a proceeding like this, but not necessarily before an ALJ. Interestingly, the Solicitor General of the United States just a couple of weeks ago in the Rahimi case oral argument conceded that administrative proceedings aren't appropriate for these type of determinations, or at least as to the Mr. Rahimi's determination.
I think that raises a good question. Shouldn't you have been in circuit court or maybe even U.S. District Court challenging the various laws?
Your Honor, I have actually represented other clients challenging these laws in regards to the Department of Agriculture and have been told that I'm not allowed to do so unless I exhaust administrative remedies first. That is an issue presently before this court, in fact.
Well, can I ask you, what law are you saying is unconstitutional in violation of Bruin?
I'm saying that to the extent that the court determines that a misdemeanor crime of domestic violence was committed by JC, a fact I don't concede, but it's an alternative argument. To the extent that JC did in fact commit domestic violence and that incident was a domestic violence incident, then I would contend that the misdemeanor domestic violence prohibition must meet the Bruin standard, and there are no founding era cases, statutes, or regulations that allow for the disarming of a misdemeanor for life.
But the statute that disarms him for life is a federal statute, the Lautenberg Amendment, right?
Well, actually, in this case, it is the argument in this case by the state of Florida is that 79006 says person is ineligible from purchasing or possessing firearms under state or federal law. So the state of Florida has incorporated and is relying on that provision of 06 to deny the license pursuant to 922G.
And you're getting to where I'd like you to address the notice of supplemental authority and the statutory change. So if it's the case that your client doesn't need a license or permit from the department, why not then seek a federal determination of the Lautenberg Amendment?
Well, Your Honor, we were well into this case well before that law changed July 1st of this year. This case has been going on for a couple of years because of issues with the department giving him the hearing in the first instance. It's only after this court's ruling in the RC case en banc that the department agreed to give JC a hearing. Previously, they were denying him a formal hearing. Secondly, Your Honor, I'm sorry, Your Honor, your question was why does the new statute not affect?
So it's mootness, really, is what we're looking at. And so the exception here, you're arguing, is that a lot of time has passed.
Well, no, Your Honor, I'm just informing the court that is a fact that's happened in this case.
And we've read the record, so
Yeah.
I think, but so give me legal arguments
The
why
legal
it would be moot.
argument, I'm sorry, Your Honor, the legal argument is this. A license is still necessary practically to carry in the state of Florida because by operation of the Federal Gun-Free School Zones Act, for example, you can't carry within 1,000 feet of a school. I mean, you can't even drive down the highway legally if you don't have a concealed carry license issued by the state of Florida. So whatever the state of Florida has done to generally permit carry without a permit is still necessary in order to comply with all aspects of both state and federal law and to practice.
Speaking on the
carry.
constitutional issue.
Yes, sir.
Let's say, for purposes of analysis, we agree that there was sufficient evidence and what J.C. did constitutes misdemeanor battery, so we come against the Bruin issue. Does this court have the authority, and I think my colleague's question touched on this, I assume your argument is under 06, this court has the authority to declare 06 unconstitutional in that it incorporates a federal law that is unconstitutional?
This court does have the authority to declare 06 unconstitutional to that extent, Your Honor. It also has the authority to decide that as applied to J.C., under the facts, record facts in the trial court, that his crime was not a domestic, or alternatively, if it was a domestic, that 922G of the federal law is unconstitutional as applied to a citizen of the state of Florida who is being denied their right to bear arms under state law.
But even if we went that direction, wouldn't the second that your client possessed a firearm, he would have violated the Lautenberg Amendment and be subject to federal arrest?
My client might have a need to seek a declaratory judgment from the local federal court regarding his rights under federal law after the state had adjudicated his rights under state law. Importantly, though, Your Honor, 922 and 921, the definitional section for 922, looks at what a conviction, what is or is not a conviction, not under any federal standards, but under the law of the state where the event occurred. So that will bring up a federalism question and a question of Congress's decision to leave it to somewhat to the states to decide whether or not a conviction occurred.
Well, you didn't address Hayes in your brief, as I recall.
Didn't address what, Your Honor?
I think it's called Hayes, where the Justice Ginsburg, writing for the Supreme Court, said that a determination of domestic type crime is not an element under 922. Now, that was a criminal case for a prosecution of carrying a concealed firearm.
Your Honor, I'm not sure if it was the Hayes. I think there's also a Castleman case that may be the case you're talking about. I'm not sure if I'm aware of the Hayes case. Your Honor,
A 2008 decision by the United States Supreme Court.
2008. Your Honor, I would say that that case is potentially no longer good law in light of the 2008 and 2010 decisions in Heller and Bruin, or excuse me, Heller and McDonald, and then followed by the 2022 decision.
But Bruin and Heller and Bruin talks about law-abiding citizens.
Your Honor, there's a question about what does the description law-abiding or the terminology law-abiding mean in each of those three cases.
I assume your argument is that it's dicta in a sense?
Not just that it's dicta, Your Honor, not even that it's dicta, but Justice Barrett was quoted in the recent oral argument in the Rahimi case as stating that she read it more as a descriptor of the individuals in those cases who were, for example,
well, when we're analyzing U.S. Supreme Court case law, I don't think we could rely on statements at oral argument, but tell me why you think, by the text of that decision, why it doesn't only apply to law-abiding citizens.
Because, Your Honor, the text of Bruin, for example, is that we reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the historical tradition of firearm regulation. Only then may a court conclude the individual's conduct falls outside the Second Amendment's unqualified command. Everything after that holding in Bruin is an example of how to apply the test that the Supreme Court set forth in Heller and McDonald and that the lower courts failed for years to adhere to.
So is it your argument here, I think, that, and I'm kind of surprised you didn't lead with that issue, although I'm not criticizing your brief, but if we reach the constitutional issue, we don't need to decide what the right burden of proof was in the hearing. We don't need to decide whether or not there was a domestic nature to this crime at all, right? Your argument is essentially that no misdemeanant can be deprived of the Second Amendment right to bear arms for the rest of their life, right?
Your Honor, that no misdemeanor should be, that is correct, Your Honor, not for life.
Well, and the Florida law, if federal didn't apply, that L there would put a temporal restriction on that. 79006L only has a 3-year prohibition on a domestic violence.
Which we are well past, Your Honor.
So it's the Lautenberg Amendment, it's federal law that's depriving your client, not state law.
Well, interestingly, under the new federal law, and this is an interesting question that also perked up during the proceeding of this case, the new federal law was passed. For years, many advocates have sought to have a dating violence element added into the Lautenberg Amendment, a fact that they were successful on within the past year or so. That dating violence exception would clearly have applied to JC at the time of his conviction, because the dating violence exception is a 5-year temporal time limit and applies to cases like his where there's some type of relationship without it reaching the spousal level. And under that circumstance,
That would have expired in 2019.
Exactly, Your Honor. And I see I'm into my rebuttal time.
Well, actually, I'm going to give you, let's say 5 more minutes, and we'll give 5 minutes to the appellees, and there's no requirement that all the time be used.
Thank you, Your Honor. Your Honor, I would just reiterate to the court that and part of my argument is the constitutional avoidance. The court doesn't necessarily need to reach the constitutional question here. The court can rely merely on the lower court's trial record that this was not a domestic, or there was insufficient evidence on the record to prove domesticity.
Even under a preponderance standard?
Well, Your Honor,
don't we need to reach your argument about what's the standard?
Your Honor, I do think you might need to reach that. You do need to reach that argument, and that's a constitutional argument as well. But that's a constitutional argument that would only be necessary to reach if you reach the point that it's not domestic or.
Excuse me, Madam Clerk, I think our clock has stopped. I don't want 8 minutes to become 80. So. Well, I understand what you're saying, and you can address it in rebuttal however much time you have.
Thank you, Your Honor.
Thank you.
Good afternoon. May it please the court. I'm Daniel Norby on behalf of the department. With me are Sean Garner and Jacob Sternlicht, also from the department. I'd like to start by addressing the issues that were tried at DOA before turning to the constitutional issues raised for the first time in briefing before this court. Most of the relevant facts here, I agree, were stipulated to below. After the department issued a notice of intent to deny the appellant's application for concealed weapons license, this case was referred to DOA solely on the question of whether the appellant's 2014 battery conviction was a, quote, misdemeanor crime of domestic violence under 18 United States Code 921A33. If so, the appellant's ineligible for a concealed weapons license under Section 790.062N and 18 United States Code 922G9. The term misdemeanor crime of domestic violence is defined under federal law. So the arguments, we would suggest, the arguments under 741.28, the Florida statute defining domestic violence, are really a red herring. Federal law defines precisely what a misdemeanor crime of domestic violence is for purposes of the federal prohibition. And it states that it's an offense that has as an element the use of physical force committed by, among others, a person similarly situated to a spouse, parent, or guardian of the victim. Now, there's no dispute here that physical force is an element of the crime of misdemeanor battery under Florida law. The only factual dispute here involved the relationship between the appellant and the victim, whether the appellant was, quote, similarly situated to a spouse, end quote, of the victim. Now, there are no Florida cases, at least no reported Florida cases, construing the federal law phrase similarly situated to a spouse of the victim. The ALJ here applied well-established federal case law establishing relevant factors for making that determination, including the length of the relationship, whether they share a residence, whether they're engaged in intimate relations, expectations of fidelity, and whether they've moved as a family unit. Paragraphs 40 to 44 of the recommended order, which are in the record at page 359 to 361, describe that federal case law. Those cases include cases from the Fifth Circuit stating that a, quote, live-in girlfriend of 2 months' duration satisfies the definition, and an 11th Circuit case from 2010, United States versus White, saying that a live-in girlfriend relationship is sufficiently similar to that of a spouse, does not require a long relationship, shared finances, or an intent to marry. So after taking factual evidence on that question, the administrative law judge concluded, based upon testimony and record evidence, that the appellant had a relationship with his battery victim, quote, similar to that of a spouse. That evidence is contained in the record and includes testimony by law enforcement witnesses from California and from Jacksonville, and the appellant's own statements and testimony at the hearing, establishing that he was living with the victim in an intimate relationship for about 2 months, that they'd moved together from California to Jacksonville across the country while they were engaged in an intimate relationship. The administrative law judge explicitly rejected the appellant's testimony as not credible, that they had no relationship other than their physical intimacy with one another. This court, of course, does not independently review the evidence or reweigh credibility determinations, but only considers whether competent substantial evidence in the record supports the lower tribunal's factual findings.
So do you think the ALJ applied the right standard of proof?
Yes, Judge. The Administrative Procedure Act provides that the standard, unless otherwise specified by statute, is a preponderance of the evidence. This proceeding is, at its heart, a permit or licensure proceeding.
But it addresses a fundamental right, correct?
It addresses the right to a concealed weapons license under Florida law.
So, because if you can't get a concealed carry license or concealed carry permit, you can't carry a firearm for self-defense. You can't defend yourself should you be assaulted or attacked or carjacked for the rest of your life, based on preponderance of the evidence, right?
Two responses to that. First, there are some exceptions to the license requirement within the statute itself. And secondly, as Judge Rowe mentioned, there's now a Florida law that explicitly provides that a license from the Department of Agriculture and Consumer Services is not needed in order
I understand
to
that, and that's interesting. This case has a lot of layers to it because appreciate your notice of supplemental authority, and the first thought that came into my mind certainly was mootness. But he's subject to criminal prosecution for the felony charge of carrying a concealed firearm under that new law because he's not eligible, if we affirm, he's not eligible for the license. He was denied the license. He can't carry that firearm without committing a felony in Florida. That's correct, right?
So Your Honor, I believe that's true, based on the facts that were proven in front of the administrative law judge.
We get into the overarching issue here in this case, which is, can the state of Florida deny a person's fundamental right to carry a firearm and defend themselves against deadly force, which happens, unfortunately? People are carjacked, people are assaulted, people are robbed. The whole idea of carrying a concealed firearm is self-defense, based on a preponderance of evidence, based on a misdemeanor conviction?
Well, two answers to that. One of them is, you suggested this case has multiple layers. We agree with that, and that's why we'd suggest that perhaps some of those arguments are best raised, as has happened before in the Edenfield case that this court decided, in the context of a criminal prosecution. In the context of a criminal prosecution against the appellant here, the state would bear the burden to prove beyond a reasonable doubt every element of that criminal violation. The defendant would have the opportunity to raise every constitutional defense that he'd like to raise in that context. In this case,
but that's kind of a dangerous situation for JC, right? Go ahead and carry the concealed firearm to defend yourself, and when you're arrested for a felony, looking at 5 years in state prison, we'll take a look at it then.
So, Your Honor, I said there were two answers. My first one is
Okay.
that. My second one is the possibility of some sort of declaratory judgment action in a federal court or in a state court, where some of these issues can be fleshed out in a more thorough way than is allowed, frankly, in the context of an appeal from an administrative permitting proceeding where the constitutional issues were raised in a rather cursory fashion in the initial brief here, that maybe another case would be a more appropriate case to consider these. And as this court knows, it gets these cases from time to time raising these issues. Maybe this isn't the best case to decide some of those significant issues here.
And counsel, is that the point of your notice of supplemental authority, to suggest mootness here and a different path for the appellant?
That's one purpose of it. The most direct purpose, as we indicated in the notice itself, was to respond to some arguments in the appellant's initial and reply brief stating that obtaining this permit was the only way to bear arms in the state of Florida, which is not true. As a consequence of this new action. So to the extent that they would moot the constitutional issues here, I think that would be an appropriate resolution of those. As it indicated on the issues that were actually tried at DOA, we believe that the preponderance standard does apply. In fact, there's no case law cited by the appellant in his initial brief or in his reply brief suggesting that there should be some standard other than a preponderance here. There's general invocations of the fact that this is an important right, but no authority cited for a different burden, nor even a statement of what that additional or higher burden should be here.
Well,
So,
can I take you back to the whether it is or isn't domestic violence? Why didn't the trial judge, the county judge's decisions, whatever she ultimately did, why is that not determinative as to whether this is or isn't, or was or wasn't domestic violence?
Well, Judge Bilbrey, a couple of answers to that one as well. The relevant definition here is not the 741 definition of domestic violence. The relevant definition for whether the appellant here is prohibited as a matter of federal law is the definition in federal law in 18 United States Code 921A33. So the domestic violence definition as a matter of state law has state law consequences, but that's not the relevant definition for determining the prohibition here. The question here is there under the federal law definition is there a crime that involves the use of physical force? Clearly, battery is. And then second to that, what is the relationship between the two of those? The state law definition has separate state law consequences. And Judge Bilbrey, I agree with what your characterization of how these proceedings often occur in county court. There was a batterer's intervention imposed as a condition of probation. When probation was revoked, the condition of probation went away along with it. But
I mean, ultimately, your contention is no matter what she did, that doesn't matter, right? It's what was presented before the ALJ that matters.
That's right. What matters, I guess, with one qualifier, it matters that he was convicted of battery. That fact, objective fact, matters. What was necessary to prove to the ALJ and what the county court judge did not determine and had no need to determine was what the relationship was between the appellant and the victim here. That's relevant as a matter of federal law for this disqualification. It's not relevant for the battery offense.
And counsel, I'd like to go back to the standard again, and whether we're talking about state law or federal law, and we're talking about disqualification provisions. So there are many disqualification provisions under the state statute, including being committed to a mental institution, and so proof of that fact would certainly deprive one of a fundamental right under the Constitution. But again, I think it's always been the case that that's been preponderance. Are you aware of any circumstance under federal law where disqualification turned on some different standard?
I'm not aware of any basis under federal law where disqualification would turn on a different standard than preponderance. We mentioned in our briefs as well, there is a bit of a conflating between the underlying federal prohibition and the permitting process that's required here. The Department of Agriculture does not enforce the criminal penalties under state or federal law for possession or for bearing arms absent a permit here. What we're talking about here is a permitting process and an application that explicitly requires these permits to be considered and hearings to be conducted under Chapter 120 of the Florida statute. So that's what's at issue here. There's no statute and there's no case law cited by the appellant suggesting a standard other than preponderance applies to that process. Again, also in contrast to a criminal prosecution where beyond a reasonable doubt would apply.
Does the statute that was mentioned by Mr. Friday on the closing the boyfriend loophole on the Lautenberg Amendment, does that have some bearing on what we're doing here?
It doesn't for a couple of different reasons. First, that amendment was explicitly made to be prospective only. Second, that amendment was, the effect of that amendment was to broaden the category of individuals who would be ineligible to possess firearms as a matter of federal law. And the amendment, I believe it was section 12,005 of the amendment, explicitly stated that it was not intended to restore eligibility to individuals who would have been ineligible under the prior version of that amendment. So it wasn't in effect at the time, it was prospective only, and if anything, it broadened the category of ineligible individuals. He was not, the administrative law judge here, based on the evidence in front of him, properly determined that the appellant's relationship to the victim was similarly situated to a spouse. So the fact that some additional categories of individuals in a dating relationship short of spousal conditions might be ineligible as well doesn't affect the analysis here. Your Honor, I'll turn briefly to the constitutional issues, just for the sake of completeness here. If this court does not dismiss that aspect of it or affirm on the basis that that aspect is moot, the appellant's initial brief included a couple of, as I said, conclusory paragraphs asserting that either the Due Process Clause or the Second Amendment prohibited the Department from denying the application for a concealed weapons license. There's no real legal analysis or argument in the initial brief on those issues. In fact, there's not a single case cited on the due process issue, and there's only some passing citations on the Second Amendment issue. The reply brief has 12 to 14 pages of new and sometimes inconsistent arguments on both of those issues. The initial brief says this is a facial challenge only. The reply brief, an as-applied challenge only. The reply brief suggests that maybe there's a facial challenge involved here. Obviously, it's inappropriate to raise new arguments in a reply brief, so we'd ask this court to disregard those. And generally, because of the inadequate briefing on the constitutional issues here, in addition to mootness, the court would be justified in saving those constitutional issues for a future case where they're more properly presented. Under the Bruin analysis, if this court does need to get there, I think our brief cites a number of cases in federal courts post-Bruin upholding the prohibition in 922 9G9 and finding under the Bruin analysis that there is a historical tradition of denying firearm rights or imposing restrictions on firearms for individuals who might pose a danger. And a misdemeanor crime of domestic violence is something that has historical analogs. The court in Bruin said it doesn't have to be a historical twin, it just has to be a historical analog. Well, the difference, particularly in an as-applied context here, the difference between felony battery and misdemeanor battery in Florida is whether you've been previously convicted of a battery. So absent the null pros on the second battery within a month here, we'd be talking about a felony battery condition as applied to this particular appellant here. And a misdemeanor battery conviction in a domestic violence situation is certainly a historical analog to various violent felonies which are disqualifying offenses and have long been recognized as such. There is a case currently pending on cert to the United States Supreme Court raising the question about the application to non-violent felonies and whether that satisfies the Bruin test.
What would be the violent felony analogs, historically speaking?
A felony battery would be one directly analogous.
Was there a felony battery in 1787?
There are certainly felony batteries, and felony conditions at the time of the founding included a number of things. Obviously, the punishments for felonies have changed over the years.
Oh, yes. A lot of hangings back then for felonies. So I don't think I understand what the analog would be here for a felony in 1787.
So what I'd point you to is then Judge Barrett's dissent in the Seventh Circuit opinion in the Cantor case, which explained, it was pre-Bruin, but of course she joined Bruin as Justice Barrett, and she laid out an analysis that might be instructive here on the scope of the right as it was understood and the scope of the legislature's authority with respect to the right, being recognizing that there are certain categories of dangerous individuals who can lawfully be deprived of their right to keep and bear arms.
If you'll bear with me, and I appreciate you getting here, what type of dangerous individuals would be deprived of firearms in 1787?
So
other than armed robbers who were sentenced to death, murderers who were sentenced to death, horse thieves who were sentenced to death, what violent felonies would be an analog here where you wouldn't be hanged or sentenced to death, and you could be deprived of a firearm in 1787.
So we cited a few different analogs in our cases, in our briefs rather, and a number of district court decisions. In fact, I looked this morning, and it seems like there's a few more that we can provide to you, but it appears to still be the case that unanimously federal district courts post-Bruin have rejected challenges to 922G9, and they've looked to a number of historical traditions. Again, it doesn't have to be a historical twin.
I understand, so
Yeah.
if you don't mind just paraphrasing what some of those analogs are.
Sure. So at the time of the founding, there were felony convictions for a fray. There were felony offenses for murder, for kidnapping. There were other offenses at the time that could be punished. And there's, in fact, as Heller stated and Bruin reiterated, Justice Alito's concurring opinion, these longstanding prohibitions on felony deprivation of firearms restrictions aren't called into question by those decisions. As I mentioned, Judge Barrett's dissenting opinion in Cantor, she laid out this idea of dangerousness being maybe a touchstone. In that case, she would have held that a nonviolent felon could not be deprived of it. The Third Circuit recently, in the Range case, which is pending for certiorari, said that someone who was convicted of a felony for falsifying an application for food stamps, I believe, was not the sort of dangerous person that could be deprived of it. So there may be some cases around the margin that present closer and more difficult questions. The challenge here, as it's framed by the appellant, is an as-applied challenge. So the particular circumstances of what he has done based on this record are relevant. What we're talking about here is someone who has been convicted by a court of a violent felony. Or excuse me, a violent crime, a violent misdemeanor crime to be sure, but a violent crime. So if we're talking about cases such as Rahimi that was argued at the U.S. Supreme Court last week involving a civil domestic violence restraining order, or if we're talking about non-violent felonies, the violent criminal conduct here is a much closer analog to some of those violent felonies than it is to some of those cases that maybe present different questions.
And that's a relevant question when we're looking at the federal decisions, right? So it's not whether, so if the Florida legislature wanted to slap a misdemeanor label on aggravated battery, with a deadly weapon, let's say, just something kind of absurd, we wouldn't be looking at the label as much as the conduct. And is that your understanding of Bruin, Heller, and the other decisions you've cited in the brief?
It is, and I think that's a logical consequence. The cases do refer to law-abiding and responsible citizens. It's not our position that provides free rein to the legislature to decide what a law-abiding citizen is, and someone who doesn't recycle because is suddenly to be deprived of their rights. It's intended to get at these sorts of issues. It was descriptive of the particular plaintiffs in those cases, to be sure. I think it goes a little beyond that, and historically the legislatures have restricted the rights of firearms by people who would place the community in danger. Not only people subject to felony convictions, but the mentally incapacitated. Someone who's been adjudicated to be mentally incompetent maybe is not culpable in a criminal sense, but it might present a danger to the public if they were to have access to firearms. So those sorts of conditions are consistent with this history and tradition and with the text of the Second Amendment in these contexts. So if this court reaches those issues, we'd ask you to say, in the context of an as-applied challenge here, that there is not a constitutional restriction on the denial of a concealed weapons license to someone who's been convicted of a misdemeanor crime of domestic battery. And on the DOA issues, we'd ask you to affirm on the basis of competent substantial evidence. Are there further questions? Thank you very much. We'd ask you to affirm.
Thank you.
May it please the court. Touching briefly on the ALJ's determinations, the federal case that said living with somebody for 2 months had other factors that went along with it, not just the 2 months living together. And those additional factors are the things the ALJ never reached because there was insufficient evidence in the record or offered by the state, such as any evidence that these two people actually lived together. There was a comment written by an officer that he couldn't remember, that he didn't put in quotes, and as he stated in his testimony, he only put accurate things in, or only put specific statements in quotes when there were specific statements, and otherwise they were a summary of his conversations with people.
All right, and to the extent that is what it is, I mean, give us some legal support for your argument that the standard should be something other than preponderance here. Federal or state when we're
Correct.
talking about disqualification?
So, Your Honor, first of all, as to the question of why the standard should be something other than preponderance, this is the only licensing that goes through the Department of Agriculture or any other state administrative agency that deals with a constitutional right, that prohibits the exercise of a constitutional right until you obtain that license.
A doctor or a nurse, I mean, they have a right to work. Isn't any occupational license
No, sir.
A constitutional right? I mean, the Florida Constitution has a right to work. So isn't that imposing something on a constitutional right?
Actually, Your Honor, the case law on, and I don't have those cases at hand, but the case law that I've read regarding occupational licenses has a higher standard to take them away once they've been obtained, but it's
Obtained, but we're talking about getting a license.
they're only a preponderance standard to get them, and there is no fundamental individual pre-existing right that pre-exists the Constitution to become a doctor. There is a pre-existing right to bear arms that is then enumerated in the Constitution because, as the Supreme Court said, we the people made a decision to enumerate this right as being protected against government interference, taking it out of the hands of the other branches of government. Which brings me back to the question.
Well, before
I'm
you go
sorry.
on.
Yes, Your Honor.
What should the standard be?
The standard should be at a minimum, Your Honor, clear and convincing. I would, as an example, some examples, the Baker Act process requires clear and convincing. The risk protection order cases, we talk about the Constitution, that statute another time, but it requires clear and convincing evidence in order to deprive a person of this right to bear arms. So at a minimum in civil proceedings, we have generally a clear and convincing standard to deprive this constitutional right. Turning to
What is your client's burden at the initial stage?
So, Your Honor, my client's burden was to prove by preponderance that he had met the qualifications by submitting the affidavit of eligibility and the training certificate. We are not challenging the constitutionality of those requirements here, but maybe those are subject to challenge in some other case. So I just don't want to concede that point. But his burden was to, and the ALJ found that once he in fact, the department agreed, once he submitted his application with all the requisite money and items that were to be obtained under the statute, that the burden at that point shifted to the state.
So if we rule in your favor, if we hold in your favor, the remedy is a remand for another hearing?
I think the remedy in this case, Your Honor, is a remand that there is insufficient evidence this is a crime of domestic-based crime, or alternatively, reverse and remand that the statute is unconstitutional to the extent that, as applied to J.C., that if it is domestic, that it can bar him for life.
Why wouldn't we just set the agency action aside and let the executive, do with it what it will at that point? Is that really within our purview to be telling the executive branch exactly how to administer this ruling? If we say, look, you're wrong on your interpretation of the statute, where does our role end?
Your Honor, you could say that you're wrong on this, send it back to them, and that would leave us in the position of either they accept that they're wrong and give him new proceedings, or take some other action. Presumptively, frankly, at that point, there might be a mandamus action to issue the license, because at that point there's a ministerial duty to issue it once he meets the qualifications. If they don't have.
And what would be the basis of our holding, setting aside the order? On what basis? That the wrong standard was applied?
The wrong standard was applied, that the evidence was insufficient, or
Under that standard?
Sir?
Under the standard of clear and convincing?
Yes, sir. Or even under preponderance standard for that matter. Or that the finding of the Duval County judge is the only judge with jurisdiction to make a determination of whether it's domestic or not, and by not doing so, by not imposing the minimum mandatory for a domestic, it's not a domestic, and the ALJ had no jurisdiction to enter this order. That's a third alternative. And actually, probably, I believe the most proper alternative ruling is that the ALJ was acting outside of his authority in reviewing the circuit court or the county court judge's work in Duval County in 2014.
And you made that argument below?
Yes, sir, I did make that argument below. Your Honor, to the question of what historical analogs has the state provided, the answer is none. What historical analogs are cited in the cases cited by the department? The answer is none.
Can I
Yes,
ask
Your
you about
Honor.
that? Because I think when you are comparing Bruin against a lifetime deprivation of a Second Amendment right, that's some concern, right? But the thing that's depriving your client of his Second Amendment right for life is not Florida law, other than Florida law says you got to apply federal law. It's the federal law that's depriving him, right?
Yes and no, Your Honor. Florida law deprives him for life, too, under its own terms.
Only because it says you got to apply federal law.
No, sir. But also 790.065 deprives him for life, and 790, I can't remember if 7923 also applies, but 065 would deprive him for life based on if FDLE believes he's been convicted of misdemeanor domestic violence. But, Your Honor, I want to make clear, there's no case, or excuse me, no historical analog regulation cited by the department or cited by any of the courts that the department cites to. The Rahimi 5th DCA, or 5th Circuit Court, the 5th Circuit Court in Rahimi, it undertook the work that Bruin told the courts to do. It said, government, give us some historical analogs. The government did its job. It laid out 3 categories of what it called historical analogs, and the 5th Circuit said none of the 3 of these categories of laws apply. They didn't apply either because they were going armed laws, not laws about possession, or they were colonial surety laws. If the state of Florida wanted to pass a surety law that people who were convicted of misdemeanor domestic violence must post a surety in order to be able to continue to exercise their right, possibly. That's the closest analog there is. As for the laws for disarming the dangerous, every case that the United States attorney was able to offer to the Rahimi court, where they actually offered the historical regulations, the Rahimi court found insufficiently analogous to deprive somebody for life. In this case, the government has offered no analogs at all, much less ones for this court to analyze. All they have offered this court is a series of citations, mostly pre-Bruin, and even in the post-Bruin cases, those courts didn't do the Bruin job. They didn't hold the government to bringing in evidence of a historical regulation. They merely said, well, the court said
You've got
that these are
5
presumptively lawful.
seconds.
Thank you, Your Honor.
Thank you both. Court is in recess.